Welcome to my channel. Let's look at the relationship between the principal and the third parties. So we have two cases. There is a case when the principal is disclosed, then there is a case when the principal is undisclosed. So when the principal is disclosed, meaning the principal's identity is known to the third party. So in this case, the principal has the right to sue the third party, and the third party can also sue the principal. Here, the third party we are talking about is usually the customer. So if the principal's identity or existence is known to the third party, the principal has the right to sue the third party in case of anything. Then also the third party has the right to sue the principal in case of anything. Yeah, and the agent typically has no rights or obligations under the contract. So the agent can't sue or can't be sued when the principal is known. Then when the principal is undisclosed, or the undisclosed principal, the principal's identity is unknown to the third party at the time of contracting. So in this situation, the agent may personally be liable for the contract because the customer doesn't know that there is someone else behind the contract. So they only know the agent as the owner of the goods. So in this case, the agent may be personally liable for the contract, but then the third party can later shift the liability to the principal once their identity is revealed. And the third party cannot sue both the agent and the principal at the same time. They choose one. Yeah, so that is the relationship between the principal and then the third parties. Let's look at the relationship between a third party and an agent. An agent generally does not have personal liability for the contract if they negotiate on behalf of their principal, unless certain exceptions apply. So if a real estate agent signs a contract on behalf of the landlord, only the landlord is liable. The agent is not liable. The agent is liable if they agree to take personal responsibility. For example, an agent guarantees payment to a supplier if the principal fails to pay. So that means that they will be liable since they took personal responsibility. Yeah. If it is a standard for agents to be liable in that trade, they are responsible. For example, in shipping, agents often take responsibility for cargo delivery delays. So in that case, they are liable. So if it is a trade practice or a standard practice for agents to assume personal liability, then they will be liable in that case. Then another thing, when the principal is undisclosed. So if the principal is undisclosed and the third party doesn't know about their existence, the agent may personally be liable, or the third party can sue the principal once their identity is revealed. The agent acts for themselves. So if an agent acts for their own benefit, they are personally liable. For example, if an agent buys property for themselves instead of buying it for the principal, they are personally liable for their actions. Yeah, then another one is for the non-existent principal. If an agent contracts for a principal that does not exist, they will be personally liable. But if the principal is later formed, they may ratify the contract. So if an agent acts for the principal that is not there, they are liable. For example, an agent signs a contract for a company that has not yet been incorporated or legally formed. It means they're acting for a principal that doesn't exist. But later on, that company may be incorporated. So therefore, the principal will just ratify the contract. Then we have the bills of exchange. If an agent signs a bill of exchange without indicating that they're signing on behalf of the principal, then they will be personally liable.